I am James Dickey, Senior Counsel for the Upper Midwest Law Center, Minnesota's nonprofit public interest law firm that fights for liberty and the rule of law. Welcome back to the Minnesota Law Report, where we update you on important developments on legal issues in Minnesota and how we at UMLC are your voice fighting for you in the courts. For those of you who follow our weekly newsletter and visit our website, you know that we have had a flurry of decisions on UMLC lawsuits, with good results and some bad results. I encourage you to read up more on these decisions and actions by subscribing to our newsletter at umlc.org and following us on Facebook, X, formerly Twitter, Instagram, and LinkedIn. We do our best to deliver you timely updates on the status of each of the cases we bring in an easy-to-access format. For our podcast today, however, I am going to delve into an excellent decision by the Eighth Circuit Court of Appeals reversing a discrimination and retaliation case in our client's favor. In our Aaron Norgren versus Minnesota Department of Human Services case, we got an important victory in the Eighth Circuit Court of Appeals. We brought this case on behalf of Aaron Norgren, a security counselor at the St. Peter MSOP facility. The Minnesota Department of Human Services had required Aaron to undergo so-called trainings called How to Be an Anti-Racist and Understanding Gender Identity and Expression, Moving Beyond the Binary. The trainings were expressly designed to, quote, change minds for life. The anti-racism training, as it's called, mandated a minute of silence for George Floyd and directed Norgren to stop using the phrase, I am not a racist, as a defense, to admit to their version of the word racist, and to accept that the United States is the root of racist ideas. The gender-nonbinary training required Aaron to refrain from telling others that their gender identities are wrong. Aaron objected to the anti-racism, as it's called, training because he believed it was forcing employees to accept ideas that are contrary to the colorblind equality required by the law, and thus was itself discriminatory. He objected to the gender-nonbinary training because he believed it forced him and others to contradict his sincerely held religious beliefs. Aaron believes that God created men and women in his image and likeness and only created them male and female at birth. As such, Aaron does not believe there are more than two genders, or that one's gender is separate from his or her biological sex, or that it can change from how they were created by God at birth. That is not controversial. It's Genesis 1:27. Aaron objected to these trainings and sought an exemption from them. He was denied. After Aaron objected to these trainings, which he was forced to take, he experienced discrimination and retaliation. First, he was denied the day off due to a winter storm, during a winter in which he had just gone into the ditch on the way home a week before. Then, after he charged the DHS with discriminating against him in the Federal Equal Employment Opportunity Commission, the EEOC, because of his objection to these trainings, they denied him the opportunity to interview for a position that he had been told he qualified for just a couple months before. So what happened to lead them to change their mind about his qualifications? Well, just 3 weeks before he applied, he had filed that charge of discrimination. In the federal district court, the court dismissed Aaron's claims, holding that he didn't allege enough in the complaint to show that he could eventually win the case. But the Eighth Circuit Court of Appeals reversed the district court. The Eighth Circuit revived Aaron's claims for discrimination and retaliation under Title VII. The court held that Aaron's allegations that he was not allowed to interview for a better position were close enough in time to his charge of discrimination that they give rise to an inference of discrimination and retaliation, and that his claim that he had been told he was qualified for the same type of position in the past was also sufficient to create an inference of discrimination and retaliation. With this reversal, the case is sent back down to the district court. Now, with UMLC representing him, Aaron will seek to prove, through direct testimony and circumstantial evidence, that DHS did, in fact, take the actions against him that it did because of his religious beliefs and because of his objection to these efforts to indoctrinate him against his beliefs. This process is called discovery, and it will go on for several months before the parties likely ask the district court to rule on what's known as summary judgment. This means that we and the state will each submit papers to the court arguing that with the facts shown in discovery, we are entitled to judgment. It remains possible that there could be fact disputes that require an eventual trial down the road. The Aaron Norgren case is an example of the type of case we bring at UMLC. We stand up alongside individuals who are courageous enough to stand against wrongful government or private sector action in employment, education, election integrity, and so on. These are not easy cases. The government has our tax dollars supporting it and its attorneys, and access to a number of defenses and immunities that make lawsuits hard to win. As I like to say, with all of their defenses and immunities often provided to them by the courts beyond the text of the law, government attorneys have to resist the urge to think they hit a triple when they wake up on third base. But we bring these kinds of cases to hold the government accountable for its actions and to provide support and hope for folks in the upper Midwest who don't necessarily agree with the government's approved and preferred messages and mantras. We look forward to bringing this case and our other cases to a successful conclusion. We also have a number of other case updates that we won't get into right here, though we may feature them on a future podcast. In the meantime, again, please be sure to subscribe to our newsletter and check out our website and social media pages at umlc.org and on Facebook, X, Instagram, and LinkedIn for timely updates on our work. And finally, I am happy to report that we will be in a new office location after the arson attack against us in the next month or so. We continue to work remotely at this time, and we have been finding creative ways to collaborate in person with one another. We thank you for your continued support in the face of the arsonist's cowardly attack. And I am happy to say that the arsonists have not stopped us from doing our important work one bit. We hope they will be brought to justice soon, with now a $100,000 reward offered from us, Center of the American Experiment, and Take Charge for information leading to their conviction. But no matter what, our ideas and our support for our clients are not encased in brick and mortar, and we will keep doing the important work we have been doing. And rest assured that in our next office location, we will have substantial security updates which will ensure any such future would-be perpetrator will be stopped immediately and swiftly brought to justice. That's it for this week on the Minnesota Law Report. You can learn more about the Upper Midwest Law Center by visiting umlc.org, and you can also make a confidential, tax-deductible donation on our website. As always, we urge you to do that. We are fully donor-supported, and we charge our clients nothing. We are standing up for you in court and want to fight for you on every front. Help us do more for you by making a donation today. Thank you, and we'll see you next time.